afternoon, and thank you for joining us for today's webinar. Before we get started, just a few housekeeping notes. For the benefit of all participants, attending lines have been muted. Should you have any questions that you would like to submit during the event, you can submit them through the question and answer space. If we can't address your question during today's webinar, we'll follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Please note Denton's can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via a mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you'll need to enter the code word into the Q&A section of the screen. If you don't have a license in these states, you can disregard this. So without further ado, welcome again. I'm John Solomon, a litigation partner at Denton's Louisville, Kentucky office. And for the next 60 minutes, we'll be exploring the attorney-client privilege in the corporate context, a topic that sits at the heart of how modern organizations like all of yours will communicate with counsel, manage risk, and navigate investigations. As all of you, I'm sure, already know, this is a critical topic for in-house counsel like yourselves, because for practical purposes, in-house counsel are typically the guardian of the privilege for their organizations. And you may very well be the first line of defense in protecting and maintaining your company's privilege. As we'll discuss, this can be a nuanced topic with distinctions based on factual circumstances and the jurisdictions involved. Obviously, we can't make you experts on the attorney-client privilege in just 1 hour. But our hope is to cover the key concepts so you can all become better issue spotters. And here, being able to recognize and flag potential privilege issues is really way more than half of the battle. And if you can do that, you can always find the answers that you need, which we here at Denton's are always willing to help you with as well. So let's talk briefly about the roadmap for today's session. We'll start by looking at the historical foundation and rationale of the attorney-client privilege, and then turn to how it has evolved in the corporate setting, including some complexities that arise when the client isn't a person, but it's an entity. I'll walk you through some key cases: Upjohn, Hickman v. Taylor, CFTC versus Weintraub, and Andre Kellogg Brown and Root, KBR, to outline some of the key considerations underlying the attorney-client privilege. And understanding the policies behind the privilege will hopefully help you think through and analyze specific issues that may arise in your workplace. Eddie Reich in New York, who is our own firm's general counsel, will then discuss the intersection of the attorney-client privilege and investigations, as well as some practical challenges related to internal investigations, which we know may be a topic of interest to many of you. And then Kristen McCall, who's also a litigation partner in our Louisville office, will cover interactions with various third parties and multi-jurisdictional considerations. And we know that many of you joining us today also operate in multiple jurisdictions and even internationally. Finally, we'll close with some practical guidance and best practices for protecting the attorney-client privilege in your workplace. So let's get started with the historical background and rationale for the attorney-client privilege. The attorney-client privilege is one of the oldest evidentiary privileges known to the common law. And I'll come back to this in a second, but it's really important to remember that it is an evidentiary privilege. Its roots trace back to 16th century England, where courts recognized that clients should be able to confide in counsel without fear that those communications will later be used against them. The rationale is simple but powerful. The attorney-client privilege encourages full and frank communication between attorneys and their clients, thereby promoting broader public interest in the observance of law and the administration of justice. In the individual context, the privilege protects confidential communications made for the purpose of seeking or providing legal advice. And just as a footnote here, it's important to remember that as a matter of professional responsibility, and I'm referring to ABA Model Rule 126, we as counsel all have a corresponding ethical duty to preserve the confidentiality of client information. So it's critical that we understand the scope of the attorney-client privilege so that we don't inadvertently destroy or waive it. Generally speaking, for the attorney-client privilege to attach, the communication must be 1, between a client and a lawyer or their agents, 2, made in confidence, and 3, for the purpose of obtaining or providing legal advice. The evidentiary privilege is not absolute. It can be waived. And importantly, it does not protect underlying facts, only the communication itself. And this comes back to the idea that it really is an evidentiary privilege and it's an important distinction that we all learned in law school, but worth a reminder here. The privilege is evaluated as to individual items of potential evidence. So we have to think about privilege as to specific communications, whether written or oral. The subject matter is important to whether a particular communication qualifies for the privilege, but there are not privileged topics. There are only privileged communications. Another way of saying this is the US Supreme Court's way, is that the privilege only protects the disclosure of communications. It does not protect disclosure of the underlying facts by those who communicated with the attorney. So what that means for us is we need to analyze each communication or prospective communication individually. If our intention is for the communication to not become discoverable, we have to make sure that it's framed so as to qualify for the application of the attorney-client privilege. And we'll share some practical tips later for how to do just that. So now we all understand the basic rationale of the attorney-client privilege and the traditional requirements for it to protect communications between the lawyer and the client. Now let's turn to your world of in-house corporate counsel, where things quickly get more complicated. Because a corporation is an artificial entity, it's a legal fiction, and a corporation can only communicate through its officers, directors, and employees. So the key questions in the corporate context then become, one, who is the client? And two, which communications are covered by the privilege? There's another rule of professional responsibility, ABA Model Rule 1.13, which really only helps a little bit in defining who is the client here. The model rule says a lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents, and that those lawyers should act in the best interest of the organization. But really, as a practical matter, that only helps a little bit to know that the organization is our client and trying to figure out who's within the scope of the attorney-client privilege. So courts have had to address who in particular is the client in the corporate context for purposes of the attorney-client privilege. Before the early 1980s, courts usually applied what was called the control group test. And under that narrow standard, only communications between counsel and those corporate employees who could direct the company's legal decisions, and that was typically top management, or what we now refer to as the C-suite, were privileged. That meant communications with lower level employees, even if they had firsthand knowledge critical to providing legal advice to the company, were not protected from discovery. And the control group test ultimately led to inconsistent and impractical results. It discouraged internal investigation and limited the ability of counsel to gather facts, and really it failed to reflect how modern corporations function. So as we'll discuss, the manner in which US courts have viewed the attorney-client privilege in the corporate context has really evolved significantly over the past 40 or so years. And I want to walk you through 4 cases that really define modern corporate privilege law. The first being Upjohn Company versus United States, 1981, opinion of the US Supreme Court, which is really the seminal case on corporate privilege, and most of you probably remember it from law school. The issue there arose after Upjohn's in-house general counsel conducted an internal investigation into potential bribery of foreign officials, which involved sending confidential questionnaires to all foreign general and area managers. The IRS sought the completed questionnaires and interview notes, arguing that only communications with senior management were privileged, which was the control group test. The District Court for the Western District of Michigan enforced the IRS summons for documents. The Court of Appeals for the Sixth Circuit, just up the road from us in Cincinnati, affirmed in part, reversed in part, and remanded. The Supreme Court granted cert, and then Justice Rehnquist, who wasn't yet Chief Justice, wrote for the court and rejected and replaced the control group test. Instead, the Supreme Court held that the attorney-client privilege extends to communications by any corporate employee made at the direction of corporate superiors for the purpose of securing legal advice. In doing so, the court held that the control group test frustrates the very purpose of the attorney-client privilege by discouraging the communication of relevant information by employees of the client corporation to attorneys seeking to render legal advice to the client. As a result, the Supreme Court in Upjohn replaced the control group test with a new subject matter test. And Upjohn really stands for the principle that the attorney-client privilege protects communications with corporate employees from disclosure, where 4 criteria are met. 1, the communication is made by employees to corporate counsel at the direction of corporate superiors. 2, the purpose of the communication is to secure legal advice from counsel. 3, the subject matter of the communication relates to the employee's duties. and 4, the communication itself is confidential. So these 4 criteria are really the key takeaway from Upjohn. If it is important to protect communications from potential discovery, we have to make sure that the 4 Upjohn criteria have been met and that we've created a record of that, ideally as part of the communication itself. And in doing that, a really important consideration that we'll touch on a little bit later is distinguishing legal advice from business advice. It's important to recognize that distinction and make sure we're framing our communications in recognition of it. Because Upjohn involved an effort by the IRS to seek the production of attorney notes and memoranda of witness interviews, the Supreme Court also touched on the attorney work product doctrine in Upjohn. So after discussing its prior opinion in Hickman v. Taylor, the Supreme Court held that notes and memoranda sought by the IRS were protected by the attorney-client privilege to the extent they included and would reveal privileged employee communications from the interviews. But it also held that they were separately protected by the attorney work product doctrine to the extent they included attorney mental processes and evaluating the employee communications. So although Upjohn is really an attorney-client privilege case, not an attorney work product case, it does touch on the distinction. It's worth taking a detour back to the court's opinion in Hickman v. Taylor, which really laid the groundwork for Upjohn. So Hickman v. Taylor was a work product doctrine case. It was a 1947 Supreme Court case that involved third-party witness statements and notes that defense counsel had prepared after a tugboat accident, where 5 of the 9 crew members had drowned, and litigation could be reasonably anticipated. So plaintiff's counsel later sought discovery of these witness statements, and the Supreme Court ultimately refused to compel their disclosure, reasoning that doing so would demoralize the legal system by discouraging lawyers from recording their thoughts and strategies. Hickman really established the separate attorney work product doctrine because the court there realized that with the notes at issue, stated expressly that the third-party witness statements and notes at issue there were not protected under the traditional attorney-client privilege doctrine. And so it really set up a separate independent means to protect those through the attorney work product doctrine to protect materials prepared by counsel in anticipation of litigation. The key ingredient for attorney work product recognized by the Supreme Court in both Hickman and Upjohn is attorney mental impressions. And the court referred to the policy underlying the privacy of attorneys' professional activities. So the key takeaway here on the attorney work product doctrine is that if you want to protect your work product, like interview notes, witness statements, memoranda from potential discovery, make sure your work product reflects its preparation, anticipation of litigation, and make sure it's based on your own thoughts and mental impressions and that you're exercising professional judgment. We move quickly through 2 more cases. CFTC versus Weintraub was a 1985 Supreme Court opinion that really addressed who controls a corporation's privilege. And the Supreme Court held that the power to waive the privilege rests with current management, or in bankruptcy, the trustee, this was a bankruptcy case, not with former officers or directors. And so the takeaway from Weintraub is that the corporate privilege belongs to the entity itself, not the individual officers or directors. And when management changes, control of the privilege changes with it. And I've dealt with this personally in the governmental context, and the same concept generally applies, that the privilege belongs to the office, not the former office holder, which creates some interesting situations that we've all read about. After elections, when administrations change and political parties and control change, and who then controls the privilege. So in the corporate context, again, just important to remember that the corporate privilege belongs to the entity itself. And then finally, Andre Kellogg Brown and Root, which was a 2014 opinion of the DC Circuit, which addressed privilege in the internal compliance context and really reinforced the subject matter test that was adopted in Upjohn and extended it to the compliance context. So in KBR, KBR was a defense contractor, and it had conducted an internal investigation after receiving allegations of misconduct. The government sought production of related documents as unprivileged business records and argued that the investigation had been business-driven and not for the purpose of obtaining legal advice. After reviewing the documents in camera, the district court agreed with the government's position. But the DC Circuit reversed on appeal, holding that communications made during investigations are privileged if one of the significant purposes was to obtain or provide legal advice. Then Judge Kavanaugh found that KBR's assertion of privilege was materially indistinguishable from Upjohn's assertion of privilege in that case, and noted that as in Upjohn, KBR had initiated an investigation to gather facts and ensure compliance with the law after it was informed of potential misconduct. And as in Upjohn, KBR's investigation was conducted under the auspices of its in-house legal department, and that the same considerations that led the court in Upjohn to uphold the corporation's privilege claim applied in KBR. So ultimately, the DC Circuit reaffirmed that the application of the attorney-client privilege in the corporate context does not require securing legal advice to be the primary purpose of communication, but just one of the significant purposes. And the key takeaway from KBR is that in the context of an organization's internal investigation, if one of the significant purposes of the investigation was to obtain and provide legal advice, the privilege will apply. So for you, that means make sure that you create record that internal investigations are being conducted at the direction of counsel for the purpose of obtaining or providing legal advice. And so I've now crossed over a little bit into internal investigations. It's probably a good time to segue to Eddie, who is going to discuss some practical challenges in investigations.
Thanks, John, and good afternoon or good morning, everybody. Depending on your company, investigations can be a big part of the role of general counsel. And investigations arise in a number of different contexts. There are a number of different types of investigations. They could involve employment issues, fraud investigations, compliance investigations, all different types of issues, all of which bring their own sort of specific issues and peculiarities around them. And they all bring various risks. And obviously, one of those risks is the potential loss of privilege. And when I say loss of privilege, there's really sort of two separate but very much related ways to lose privilege, and kind of using that term a little bit loosely. That could either be because a communication is not privileged in the first place. So you haven't satisfied the various criteria that John walked us through. And you could also lose the privilege by waiving it, so that the privilege attaches at some point. You satisfy all the requirements that John talked about, but because of various steps you take or don't take, that could result in a waiver of the privilege. And I want to start by amplifying a couple of points that John made that are both very basic, but sometimes overlooked, and are particularly important to remember when embarking on an investigation. So first of all, as John talked about, well, not everything is a privilege, and we all tend to throw that term around very loosely. Even very sophisticated lawyers will say, "Oh, well, I'm an attorney, you're a client, it's privileged." Or, I've drafted something, I'm an attorney, I drafted it, it's privileged. That's not the case. So, as John pointed out, a client's right to confidentiality protection and an attorney's confidentiality obligations really emanate from primarily three separate sources. First is, as we've discussed, the attorney-client privilege, which is, John pointed out, is a rule of evidence. The second is a duty of confidentiality, which is much broader than what would fall within the privilege, which would fall within the attorney-client privilege, and that emanates from the rules of professional conduct that vary from jurisdiction to jurisdiction, but generally hold that anything you learn from a client, the lawyer has a duty to keep confidential. And the third is work product, which really is a rule of civil procedure and is very different from the other two doctrines that I just described, and really carries with it its own separate obligations and obstacles. So it's important to get these distinctions right, because there are potential consequences if you're not using them correctly. And we'll get to those in a little bit. The second, and this is even more of a basic element of the privilege here, is that the communication be with an attorney. And that's something we take for granted often if there is an attorney involved. But there has been a spate of cases that where privilege between in-house counsel and corporate client are challenged. And they're challenged because, for whatever reason, the lawyer is not properly admitted in the jurisdiction in which he or she practices. Maybe he or she is admitted in Massachusetts, but actually works out of New York. Maybe the lawyer let their bar license lapse when they went in-house. I know law firms are very attentive to these types of issues and make sure that their lawyers are admitted and confirm that their lawyers are admitted, or at least they should. We certainly do. My own experience is that in-house departments are a little less so. It could also be because someone failed to take their CLE. And there have been, as I said, a number of cases that have addressed this issue. And one in particular in the last few weeks, which is out of the Court of Appeals of Georgia, called Royal Texas versus Cajun Global. In that case, the general counsel of the company had let his bar admission lapse some years ago. And the other side in litigation asked for all communications from and to that in-house counsel, on the theory that, well, the privilege shouldn't apply because he is not a lawyer admitted to practice in any court. Now, I think I won't let the tension rise too much, but the court ultimately upheld the privilege, applying the reasonable belief test that the client, that the company concluding that the company had a reasonable belief that this guy, who had been general counsel in a couple of other companies, was in fact a properly admitted lawyer. I'll be honest with you, and maybe you're not supposed to do this in CLEs, but I think that the court's reasoning there was a little questionable. The court decided that, well, it would have been too much of a burden for the company to confirm that the lawyer was admitted. Perhaps the judge is not particularly familiar with something called Google, because it really takes all of 5 seconds to confirm whether someone is admitted in a particular jurisdiction. So my point here is that it could have gone easily the other way. And this is not uncommon within in-house departments, at least in my experience. And while during COVID, courts were being pretty flexible, and state bars were being pretty flexible in terms of dealing with unauthorized practice of law, given that everyone was working remotely, et cetera. The pendulum is starting to swing back the other way. So I do think it's something that I would caution folks to make sure that the in-house lawyers at their company are properly admitted, have kept up with their dues, have kept up with their CLEs, because it is an easy way to actually, and this is a case where the privilege wouldn't apply in the first place, because a court could easily find that there was no communication with an attorney that is protected in the first place. So I can't see anybody on the screen, but I sort of envision a lot of people starting to email their HR departments or in-house folks to make sure they're admitted. So let me move on a little bit more to investigations here. So another important aspect here when you're embarking on an investigation is what is the purpose of the investigation? And again, it sort of seems obvious, but courts do recognize that many of us, and look, I'm the general counsel, Denton's here, so I include myself with all of you. So this is a lot of empathy going on here because I'm dealing with many of the same issues that you are. But court recognize that many of us play roles that are well beyond counselor and someone who provides legal advice. So it's important to ensure that it is clear in all communications in your role in an investigation that you are conducting this investigation in order to, in an effort to provide legal advice to your client. That's certainly an imperative when it comes to conducting employee interviews. John talked about Rule 1.13 of the Rules of Professional Conduct. I want to drill down on that a little bit more. 113F says, in dealing with an organization's officers, employees, members, etc., a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. Rule 1.13G goes on to say that a lawyer representing an organization may represent its directors, officers, employees, etc., subject to the provisions of Rule 1.7. Rule 0.7, of course, is the current conflict of interest rules, which essentially provide that you cannot be both represent a party and be adverse to that party at the same time, absent consent and other requirements. I do want to pause and indicate that another thing that generally gets lost when you move in-house is the imputation rule. That's Rule 1.10, which says that this doesn't just apply to individuals, right? So it's not a question just of whether you individually represent X, the company or an individual, et cetera. Your whatever conflict you or somebody else in your in-house legal department has gets imputed to the rest of the department. So actually, the rules of professional conduct define the term law firm to include in-house departments. So all of those of you who thought you were leaving law firm life behind when you went in-house, according to the rules of professional conduct, that's not the case. You are employed by a law firm. This is all important because, and you all know this, right? That there are pitfalls when you are speaking to employees, some of whom are sophisticated, some of whom may not be sophisticated. And that's why it really is important to ensure that you provide the Upjohn warnings that John described earlier. And it's sort of easy to say, okay, yeah, I'll just apply them. But every employee is going to be different. Someone who is sophisticated, for example, you may think they already know it. They may not want to hear it. You may think that you sound silly when you're telling a senior officer of a company that, well, I don't represent you, I represent the company. You got to say it. Even if you sound silly, you may not think to say it when you're communicating with someone who is a sort of a tangential player. But again, that's something that you never know what's going to come out of somebody's mouth. Is sort of the rule of thumb that I use. So it's always better safe than sorry. And you also, I mean, the consequences are severe, right? If you don't provide the warnings, and if someone at some point later says, "Hey, I thought you were representing me," obviously, could be a privilege waiver, could create a conflict. If that individual is adverse, you're going to create a conflict between that individual, the company, and as a practical matter, you or the entire department could be disqualified from being in that matter. We all read about cases where law firms are disqualified based on conflicts, but there are cases out there where law departments, in-house law departments, have been disqualified as well under these types of circumstances. It's also potentially an ethics violation, and there could be a bar complaint. So these are all things that you really need to think about when you're, having these initial conversations. A number of other challenges come up. You say it, and someone says, "Well, do I need my own lawyer?" That's always a fun one to have to answer, right? And the rule of thumb I use is you never want to say no. You never want to say no, you don't need your own lawyer. But you can explain their role, your role, their role, and they should make the independent decision whether they want to retain counsel. But again, my recommendation would be never to tell anybody they don't need their lawyer. Something else that we see a lot of is where people say, well, sure, happy to talk to you, but can this just be between us? And that's a tough one too, because you want people to open up to you. But again, if you're agreeing to that, you may have just created accidentally an attorney-client relationship between you and this individual. What I always say in those circumstances is, look, I can't promise you it's going to be kept confidential between us. I represent the company, but I can assure you that I'm not going to share this, beyond those with anyone beyond those who really need to know about it. So you need to be flexible in terms of making sure that you don't create that relationship, but also that you're able to gather the information that you need from these witnesses. Another challenge here is ensuring that you are separating the legal advice or request for legal advice from business or even compliance type of advice. And sort of gone are the days when having a lawyer's name on a document creates an irrebuttable presumption that the communications are privileged. I wish I had $1 for every time someone copied me into something and said, "Oh, copying Eddie for privilege." And then they proceed to talk about, why so-and-so is a jerk or, doesn't know what they're doing, and it has absolutely nothing to do with legal advice. And what we are seeing is courts giving greater scrutiny on communications that are authored by or sent to in-house counsel. I encourage everyone to read the in grand jury case. I think that's listed on a different slide. Out of the Ninth Circuit, and John was talking about the primary purpose test versus the significant purpose test versus the primary purpose test. The Ninth Circuit in the grand jury case applied the primary purpose case in finding communications that lead to that particularly involved tax advice, that primarily involved tax advice rather than legal advice, were not protected by the privilege. There was sort of this weird procedural process there where the Supreme Court actually granted cert on that. It was briefed, and then the Supreme Court dismissed cert, saying that dismissed the case, saying that cert had been improvidently granted without any further explanation. Sort of bizarre, something that rarely happens. But that sort of left us with this somewhat of a split in terms of the primary purpose versus the significant purpose, which is admittedly a very fine line to draw. And even when we're talking about compliance advice versus tax advice versus legal advice, very fine line to draw. A few tips on how to sort of avoid some of these issues. So again, limiting the circulation of communications. That, including a stranger on what is a privileged communication is the easiest way to waive the privilege. Keep the group with whom you communicate very narrow. Again, make sure it's people who need to know. Avoid stuff like replying to all. Avoid putting documents on shared drives or sharing platforms, which, by definition, numerous people could have access to that. You may not even know who has access to it. So if you are going to do it, make sure you have control and only you have control over who gets admitted to that platform. Business advice versus legal advice. Again, this is something where you want to frame the communications as legal advice and not just throwing out buzzwords like, hey, this is legal advice. Look at the substance of the communication, because that's what courts are going to do, right? They get communications in camera. They're going to look at the substance. So you can say that something is a legal advice, but if the substance of it has nothing to do with legal advice, it's not going to pass muster. And then document labeling and preservation. This, in my view, is something where lawyers really get tripped up on. I mentioned before the difference between attorney work product, attorney-client privilege, confidentiality. One key difference with respect to attorney-client privilege is, and what I see a lot is people put every label they can on a document, because on the theory that, well, if I call it everything, I'll maximize protection. So they'll put attorney work client, attorney privilege, confidential, work product, double secret, whatever. But the reality is that courts look beyond that, and they're going to look to what it is. And there's risk involved in doing that. So, for example, attorney work product, one of the differences, that only applies to material prepared in anticipation of litigation. There's some state laws that have it broader, but as a general matter and under the federal rules, it applies only to materials prepared in anticipation of litigation. A lot of lawyers don't understand that, especially a lot of corporate lawyers. I'm an attorney. This is my work product. It's attorney work product. That's not how it works. And if you label something attorney work product, that means a court will assume that you are anticipating litigation, that you are reasonably anticipating litigation. If you are reasonably anticipating litigation, follow those, connect those dots, that means that in most jurisdictions, you have an obligation to preserve documents. And woe be to the lawyer who is asserting that he or she reasonably anticipates litigation and hasn't sent out a document hold notice, hasn't taken steps to preserve litigation, to preserve documents. I've litigated this issue. It comes up on a regular basis. So my general rule of thumb is to be as broad as possible and say, mark something privileged and confidential, or, legal advice, something like that, without specifically trying to identify something. Lastly, and I know we're running over a bit, and I'm going to turn this over to Kristen. It's important to also know the purpose when you're going into this in terms of, what are you ultimately going to do with the results of the investigation? There are some types of investigation, employment, investigation of employment conduct, when you're dealing with criminal investigations and you're potentially cooperating with the DOJ, where you may ultimately want to share or be obligated to share some parts of or the entirety of the investigation. And you need to think about, well, are you, setting yourself up for a waiver if you're providing some of that, if you're labeling something and providing some of it versus not providing all of it. So there are a lot of, I just want to flag the issue for folks. We're not going to get into details, but that's something that you should be thinking about when you embark on the investigation in the first place. Is this something I'm going to want to share more widely, or is this something and not claim privilege on it, or is this something that we want to keep privilege? So with that, I will pause and turn it over to Kristen.
Thanks, Eddie. Like John mentioned earlier, my name is Kristen McCall, and I am a litigation partner in the Louisville office. So as John and Eddie both touched on, obviously, we typically think of attorney-client privilege and attorney work product.
Hey, Kristen, I'm gonna jump in because you're sounding a bit underwater. I don't know if there's anything you could do with your speaker.
Perfect. Let's see. Eddie. Is that better? Okay. Sorry about that. I'll just get closer to it. So we typically think of privilege as applying between the client and the attorney. But as soon as a third party is brought in, there's a waiver of privilege. But there are some exceptions to this rule. And that's what I want to go through right now quickly, just so you all have an overview of when communications with a third party can still fall under the umbrella of privilege. So I'm going to go a little out of order on this slide, but first, I want to talk about the joint defense or common interest privilege. So this privilege is a doctrine that preserves the attorney-client privilege and work product doctrine, despite the disclosure of otherwise protected information to third parties, specifically co-defendants in a litigation where there is a joint defense effort or strategy that has been decided upon and undertaken by the parties and their respective counsel. And in general, a party asserting this privilege must demonstrate that the communications were made in the course of a joint defense effort. The statements were designated or were designed to further that effort, and the privilege has not otherwise been waived. Typically, these relationships are memorialized in some kind of joint defense agreement or common interest agreement to ensure that that privilege is on paper if it is challenged, because if the privilege is challenged, the burden is on the defendants to demonstrate the existence of a joint defense arrangement. Important to note that some courts have found that the sharing of confidential information creates an implied attorney-client relationship among the parties to the joint defense agreement. So often attorneys will include in a joint defense agreement or a common interest agreement written disclaimers to prevent the attorneys from being disqualified on the basis of a conflict if they have to become adverse to the other party in the litigation. So one of these disclaimers might look like nothing contained in this agreement shall be deemed to create an attorney-client relationship between any attorney and anyone other than the client of that attorney. And no attorney who has entered into this agreement shall be disqualified from examining or cross-examining any joint defense participant who testifies in any proceeding, whether under a grant of immunity or otherwise. And courts have found that provisions such as that one permit an attorney to cross-examine a witness who was a former member of a joint defense arrangement and has since become, for example, a government cooperator or is cooperating with the plaintiff in a litigation. Often now in modern litigation, we are required or we need to consult with third-party experts in furtherance of the litigation. So for example, in tax litigation, you might need to consult with a CPA, or in financial cases, you might need to consult with a financial advisor or investment bankers or other experts in order to develop litigation strategy, to respond to discovery requests, to develop legal positions, to evaluate settlement alternatives, and to generally prepare for the litigation. If the privilege were not to extend to those communications, obviously litigation strategy could be disclosed due to the required disclosure of those communications. Because of this, the Second Circuit recognized in a case called United States v. Counsel that the complexities of modern existence prevent attorneys from effectively handling clients' affairs without the help of others. The Second Circuit consequently extended attorney-client privilege to third-party professionals acting as an agent of an attorney in providing legal advice. So the key here is that for that privilege to apply, communications between the expert, the attorney, and the client must meet the requirements of traditional attorney-client privilege. And courts consider several factors, including whether the third party assisted the attorney in providing legal advice, whether the third party served as a translator on complex subject matter or merely supplied facts, in which case it's less likely that the privilege would apply, and whether the attorney directed the actions of the third party. When establishing a CLE relationship, parties should make clear that the expert is working for the attorney and furthering the attorney's provision of legal services. Best practices for this include a CLE engagement letter, file segregation, meaning segregating the work product prepared by the expert from other files in the case, privilege labels on all work product prepared by the expert, all expert correspondence should be addressed to the attorney. And the expert should bill the attorney directly. It's really important to note in this context and in the context of everything that I'm going to talk about that these laws can vary by jurisdiction. Not every state has adopted the CLE test or the CLE test in full. Some states have adopted narrower versions of the CLE test. So make sure that whatever state you are practicing in or this particular litigation is in, that you are familiar with what the laws in that state are with respect to the extension of the CLE doctrine. For example, some states have only extended the privilege to communications that are necessary rather than merely useful or helpful to the attorney's ability to give legal advice. In other contexts, attorneys might need to consult with other types of consultants as part of litigation. So for example, with PR firms, courts have extended the attorney-client privilege to include public relations consultants under certain circumstances. In particular, communications with PR consultants have been found to maintain privilege if the primary purpose of the communication was to aid in the rendering of legal advice, if the consultant provides services necessary to promote the attorney's effectiveness in the client's legal representation, or the consultant is essentially an extension of the attorney under agency principles. Again, this can vary by jurisdiction, so make sure to research the rules in your jurisdiction first. With auditors, disclosure to a company's auditors ordinarily constitutes a subject matter privilege waiver. To the extent that counsel anticipates auditors might require information about the status of an ongoing investigation, counsel should be prepared to communicate with auditors in a way that will limit the waiver of any privilege. But while the disclosure of privileged information to auditors will likely waive attorney-client privilege, work product protection may remain intact if the auditor's interests remain in line and are not found to be adverse to the client's interests. In terms of insurers, most states have recognized an insurer-insured privilege if there is a duty to defend in the insurance policy. And so the basis for that privilege is the insurer's role as an agent to the insured. Jurisdiction matters here also, and so does the language in the policy. So it's important to review the policy's cooperation clause, work with panel counsel or with your insurer's counsel, use counsel to counsel communications when responding to insurers, mark privilege documents accordingly, and get client consent of disclosure if the disclosure is unavoidable and permitted by the ethical rules. And when reporting a claim to the insurer, you should stick to factual descriptions and avoid editorializing or quoting legal advice, and consult with outside counsel before responding to the insurer if you're going to be submitting complex or sensitive disclosures. And finally, just something that might be of import to some people that are attending. Forensic reports and data security breaches have, by a growing number of federal courts, not been treated as privileged, and neither have the related communications to those forensic reports. So, for example, the Eastern District of Pennsylvania declined to extend attorney-client privilege or work product to third-party security firms because the litigation was not expressly contemplated at the time, and the work did not implicate legal advice. So just be aware that if your company has some kind of data breach and you hire a third-party security firm to come and do an investigation of the breach, that their work product might not be covered. And then just really quickly, in terms of multi-district or multi-jurisdictional work and working in the EU in particular, there's a case called ASCO Noble Chemicals Limited versus European Commission that held that internal communications between in-house counsel and their companies are not privileged in European competition law cases. Under ASCO, for privilege to apply, communications must emanate from an independent lawyer, that is to say, one who is not bound to the client by a relationship of employment. The result of this ruling is that in-house counsel in the EU must be anchored to external counsel in preparation for the protection of rights of defense in order to benefit from EU legal professional protections. So make sure that all communications, if you are in the jurisdiction of the EU, include outside counsel, and that all documents for which privilege could be sought are clearly marked as privileged, and request external counsel to produce summaries of advice provided by external counsel rather than that being circulated internally. Important to note, this doesn't apply to matters that are handled inside the nations. This only applies to European competition law cases.
Thanks, Kristen. Why don't we quickly take care of a bit of housekeeping? Can we move to the slide with the code word?
Yeah.
So as mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word privilege. Just saw it. We go back to the slide. Anyway, the code word is privilege. Type it into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word, very appropriately, is privilege. So there you have it. There's today's magic word. Probably makes sense now to move on to some practical applications. And there are some questions that we can try to address. Eddie's already touched on some of this in terms of avoiding mixing legal and business content. It's important to separate those. And one of the questions we got in the Q&A was sort of, can I lose or waive the privilege somehow if I'm, by acting too much in the business context? And that doesn't come up so much as long as you've established the privilege in the first place. That's usually more of the challenge. If you are able to establish that you are providing legal advice and acting as counsel in response to a request for legal advice, it's unlikely that you're going to waive the privilege by then crossing over into business context. The risk is, again, it comes back to specific communications. And so if a specific communication is mixing legal and business advice, you're only going to really be able to protect the legal part. So, think about segregating to the extent you can. And, life doesn't always fit into tiny categories, but as best you can, if you can separate, especially in your written communications, your legal and your business communications, and keeping email threads with privilege matters distinct, that's going to be helpful. We also got a question about AI, which is, timely and something everyone's starting to think about. There's not a lot of case law developed on that yet. But I think just, in the absence of having a lot written on it so far, two things. One, can something still be attorney work product if you've used AI to, help create it? I think the answer is yes, as long as you're not taking something that was created by AI and just slapping attorney work product on it and saying, this is my work product prepared in anticipation of litigation. You can use AI as a tool to help you create attorney work product. But remember the key ingredient from Upjohn and Hickman is, it's going to involve your own professional judgment, mental impressions. There's got to be some exercise of professional judgment there to make it attorney work product. And so you can't just slap the label on something that AI created.
Hey, John,
yeah, sorry.
Yeah, let me jump in on that also because it's a great question, and it's coming up all the time, as you know. Another thing to be very careful of in using AI is the potential for waiver of privilege if you input privileged information into an open AI platform. As John notes, there really isn't much case law on this yet. But theoretically, if you are inputting information in what would otherwise be considered confidential or privileged, you are potentially disclosing it outside of the cone of silence, right? Because that information is being used in order to train the AI platform. I mean, there are arguments both ways as to why that should or shouldn't be a waiver, but it is still something to be very careful of. So, for example, I, tell people, probably not a great idea to input all of your interview notes into ChatGPT and have it generate a summary. Because, sometime down the road, there's going to be a question raised as to, where did you, what did you do with those notes? How did you come up with a summary? And if it's something that was prepared by AI based on confidential information that you put into it, there could be an argument that you've just waived the privilege.
Yeah, I think that's great advice. And in the absence of a lot of case law on it, I would say the exact same thing. Once you put some confidential information out there into the AI, we don't really know where it's going. And you got to assume that it's being shared and that you're waiving privilege on it to the extent that it contains confidential information. So be very careful about doing that. If you want to use AI to research a topic, use hypotheticals, and you can, ask about, a particular fact pattern. But obviously, you got to be careful about how you use them.
Yeah, let me go to one other question here, which I thought was interesting, and we're pretty much out of time, so we'll make this the last one, I think. There was a question as to whether special investigations teams comprised of non-lawyers should give an Upjohn warning to employees before any interviews, recognizing that they're not lawyers and there really isn't a rule of professional responsibility that applies there. It's a great question. My general advice on that would be probably yes. The reason being because even though the individuals may not be lawyers, number one, the investigation is being done presumably under the auspices of the law department, under the auspices of a lawyer. Number two, you don't know what the interviewee believes. So the interviewee might, think that these guys are lawyers. Oh, these people show up wearing a tie, asking me all these questions. I assume they're lawyers. It's similar, I guess the analogy I would draw is, when you're dealing with paralegals, even though the paralegal per se doesn't have the is not obligated under the professional rules of professional responsibility. Lawyers have a supervisory obligations under the rules of professional responsibility for non-lawyers. So I would sort of think that this falls, I would take a conservative view on this and think that would fall within the supervisory function, and that it probably is good practice to give those warnings.
So thanks, Eddie. Sorry. For a few housekeeping matters, a few people asked, the code word is supposed to be typed in the Q&A box. And this will be shared, a recording of this will be shared after, which includes the slide deck. We'll confirm whether the slide deck separately will be shared, but the recording will be shared. Thank you all again for participating in today's CLE webinar. In approximately 30 business days, you'll receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you're seeking credit in Kansas, New York, New Jersey, or Pennsylvania. Thanks and have a great day.